where everyone will be treated fairly and equally protected. A judge is supposed to be a finder of fact, and if they had led to believe this, they would not be involved in something where there's fraud upon the court. So I'm going to go to the verified answers by Judge Talamantes. This is under penalty of perjury. So he states, I am a judge of the Superior Court in California, County Marin, and have been assigned to preside over the case. I presided over a guardianship hearing on November 5th, 2018, in which maternal grandparents sought the guardianship of the son of the petitioner. Court was covering the conservatorship for Honorable Kelly Simmons, who was not in session during the week of the hearing. After the hearing and consideration of the evidence provided, the court found good cause to grant the guardianship, as it is in the best interest of the child that is raised in a stable home with stable guardian. So this is another false statement under penalty of perjury, that they say in a safe home with a stable guardians. They have not provided evidence that I am unstable, and this is another false statement and or perjury by Judge Talamantes, because no evidence has been proven that my house is unstable and this house is not safe. I do not have a personal relationship with any attorney or party in this case. This is also a false statement because it's stated Judge Talamantes is a member of the Marin County Women Family Lawyers Group, or Marin County Women Lawyers Group, and this was the same organization where Johanna Kleppe, the mother of our child's attorney, belonged to, and together they fixed and rigged the case to kidnap our son. He belongs to this group, and so does Judge Adams, and Judge Adams has a history of fixing and rigging cases from the article Odor in the court with Judge Michael Dufusy, and they have a personal relationship with each other that has tainted this case. This is also a false statement. 4, I specifically deny petitioner's claim that I am biased. I am not biased or prejudiced or in favor of the petitioner. I am not biased or prejudiced in favor of any party or attorney in this proceeding. I know no reason why I cannot be fair and impartial. Further, I am not predisposed in the ruling in any particular matter in the instant action. In every case over which I preside, including the instant case, all rulings made by me are based strictly upon the facts and arguments officially presented to me and upon my understanding of the law. So once again, these are false statements and or perjury. This judge was sitting in the court hearing on behalf of Judge Adams and has extensive knowledge about this case, so he shouldn't be hearing it. Number 5, all statements I made and all actions I have taken in this proceeding have been done solely in the furtherance of what we believe were my judicial duties. This is another false statement because a judge is finder of fact. And if he found the facts to be that there was fraud and attorneys fixing and rigging the cases for litigation and grant fraud for the county to benefit, this would be a reason for an impartial and judge without bias to remove himself from the case. I do not believe that my recusal would serve the interests of justice. This is also a false statement because judges have a fiduciary duty. They're trusted individuals. They're not supposed to be fixing and rigging cases to help their friends make money from litigation. They're not supposed to say things are in the best interest of the child to get grant funding. So the recusal would serve the interests of justice if the judges are using their oath of office and oath to uphold the Constitution to do underhanded things. I know, and this is 7, I know no facts of or circumstances which require my disqualification or recusal of this case. So he states that, but as stated in CCP, point 1, A, the judge has personal knowledge of disputed evidentiary facts concerning the proceeding. This man was sitting in the hearing on behalf of Judge Adams when they denied the subpoena for Dr. Gilbert under the evidentiary hearing to not show up. Judge Adams said I could have an evidentiary hearing to subpoena for medical records, which would clear my name. She told the witness not to show up, the doctor. Judge Talamantes was sitting in that hearing on behalf of Judge Adams. So I have showed by this judge's verified answers that he's made false statements and or perjury. And he states at the bottom, I declare under penalty of perjury that the foregoing is true and correct, and that this verified answer is executed November 14, 2018. This document here are interrogatories that I sent the Child Support Commissioner, Michelle Moniz. What happened with this situation was that I went to the Child Support Office and I cooperated with them because they told me it was mandatory, and I thought that it was in the best interest of our child. And they kept asking me to fill out these papers, and I was wondering, why do they keep wanting me to fill out the same papers? So I went there and talked with him and spoke with Leon Tam, and he told me that it's voluntary. So when they stated that, I knew they were using fraud, extrinsic, intrinsic fraud, fraud concealment, fraud inducement. So basically they're concealing the fraud because they want these federal grant dollars under AB 1058. They conceal that it's a grant program, and they tell you that it's in the best interest of the child, which is a fraud misrepresentation, as stated by the case law in Blessings versus Freestone in Arizona, that the funds never benefit the child, and it's a way for the state to make money. The child support is a for-profit business because they sell application fees, $25 in their services. I sent these interrogatories to Michelle Moniz of Marin, DCSS, the child support agency, and she lied, to the best of my recollection, probably about 80% of the questions. So she did that under the penalty of perjury, as stated here on page 15. And some of these questions she gave evasive answers as well. And as stated, this is like a cat and mouse game. So a lot of these individuals have made false statements under oath, made false statements with unsworn declarations, made false statements and committed perjury under oath, and some have just ignored the issues at hand. This is a letter from the court CEO, James Kim. I asked him to validate and verify the authenticity of the court orders and the child support orders presented by these individuals. And I asked him to do it under affidavit under penalty of perjury, so I would know that it was authentic, but he refused. He gave me this, just like a customer service letter. So he put, "Thank you for your inquiry. I reviewed your communication as well as the court documents, your reference, and your emails. Appreciate the time and effort you have spent in communicating with the clerk's office about your concern." So there was issues, as stated, that they were using markers on the child support orders in whiteout, and he just tried to brush that off. Once the order was signed by the judicial officer, the document became an official order by the court. So once again, this is a fraud that the man is saying he's a judicial officer. If he was a judicial officer, when I struck him under CCP 170.1, he would have wrote the motion back. But this is color of law, as stated, that you think he's a judge but a judge can't work in the executive branch of government because they don't do court orders and they're not judicial. So this is another false statement, and it's stated with marked out forms. The original parties would have to agree to alterations of a document in a contract. But in the case that they made this contract that I paid child support, they coerced me into that, and you can't be forced to pay anything unless there's equal consideration. So this is just a nice way of dodging the question. He also stated that he agrees that the clerk should not use whiteout, and that he put Chris Hahn put his name over whiteout. You don't know what's beneath that, but it's stated it's an unauthorized alteration. And on some documents like checks and mortgages, they won't accept anything like that. So they've already voided a voidable document or incomplete written instrument. So he makes excuse 3 that if I require copies from the clerk's office, I could get a certified copy. But the issue is that he's passing the boot to the clerk's office, and this man is the CEO of the court. So if he couldn't set these void orders aside himself or get some clarification about it, he's just passing it to someone that can't help, as the clerk's office is not going to be able to authenticate the papers. So he basically treated this like it was I purchased products from a store. Lastly, we appreciated your feedback regarding your experience with the clerk's office. I'm sorry that you feel disrespected. Everyone in the clerk's office constantly strives to provide an exceptional level of customer service and serving the members of our community. We will take note of the issues you raise, and where appropriate, we will incorporate your feedback into improving customer service. Thank you for contacting the clerk's office with your concern. So he didn't sign the affidavit under penalty of perjury validating the void court orders. He said that I feel disrespected, but my constitutional, human, and civil rights have been violated, and our son is in danger, and this gentleman is supposed to be the CEO of the Marin County Court, and he gives me some letter like I bought a Christmas turkey or some kind of products from his store. So this is the kind of stuff that they do in Marin County, that when they mess up, they can't make it right.
And it has no authentic signature on it.
No, this is just he didn't do this under penalty of perjury, and these were all false statements. I was going to say that this is what they do in the county of Marin, that since I've recused these judges, they just stated that these are erroneous rulings. But the whole thing is that fraud upon the court and collusion is not an erroneous ruling. Those are felonies. Forgeries of documents, colluding, ex-parte communications. These are criminal acts. So the whole thing is that this is a cat and mouse game with the upper courts, the California Supreme Court and the appellate court, where these individuals in playing a cat and mouse game with me, that I have to go out of my way to prove what they're doing is wrong when they have the duty and they're appointed people, and they've taken an oath to uphold the Constitution, and they can't even make a legitimate court order. They're running around, they're fixing and rigging these cases, making unilateral adhesion contracts. What that means is a contract that favors one party over the other. So in my case, all these motions that I've filed, maybe 1% or 2% of them have been accepted. The mother of my child and her attorney, they've gotten all their stuff accepted. And this is what they're doing in Marin, is confirmed in the article Odor in the court. that Judge Adams has taken the place of Judge Michael Dufusy to fix and rig the cases. The appellate court won't set the void judgments aside because the money is going into the state treasury. And the purpose of the appellate court is to correct the illegal errors of law. But what's happened is they're not implementing the power that they have. And I presented to you in this video the perjury and the false statements of Judge Adams, Commissioner Longaker, Michelle Moniz, Judge Simmons, and Judge Talamantes. I also wanted to make a note that I made the video for people to view. Importantly, Mr. Nolan of the Department of Justice, Xavier Becerra, the State Attorney General, the FBI, Marin County Family Court, the Appellate Court, California Supreme Court, and the federal courts.
So as we see here, sir, from this article that was written in a major publication from a Michael Isaacs in 2000 of the criminal activities in odor in the court instead of order in the court, the odor is still smelling up the court system in Marin County as of today. There's no change from then to now, from this date to this date. As of today, they are still kidnapping kids, they are still extorting money, they are still doing the same criminalization, victimization that they have done from the beginning. As the people can see, this is here for you to check out, for you to research, investigate, and hopefully we can all put an end to this injustice that's being committed on a daily basis at the Marin County Courthouse.
I also wanted to state that I wanted to tell the Judicial Council on Performance, that's the governing body that they discipline the judges for misconduct. And I had reported Judge Adams to them, and they stated that they don't get involved with the rulings. So that was a nice way of them saying they didn't want to get involved. But what's happening is that the commission doesn't want to discipline the judges. It's acting in a way of a protection racket, and they're not supposed to act that way. The state auditor, Elaine Howe, was suing the Judicial Council on Performance to audit them, and an issue came up where Judge Aaron Persky was voted out because he wouldn't recuse himself when he was lenient on the gentleman from Stanford that raped a girl and he got 6 months. So I also wanted to state to them that I had made the complaint to them about Judge Adams and they just brushed it off. I also wanted to state to Elaine Howe of the auditor's office that this is what they do in the court, that they're using their oaths to the Constitution to do underhanded things for money, grant fraud, extortion, kidnapping of our son, and just all kind of things you wouldn't imagine that they do in the court. People speak out about it, but you know, a lot of these people are eating, and it's a lot of corruption. You know, I also wrote a letter to the district attorney, Ed Berberian, and I told him that I filed the letter with the court and I gave it to him in his office. He never responded, so it just shows the corruption and the color of law that you would think that these individuals would do anything, but they're not about it. They don't care.
And how about the appellate court, sir? Have you had any interaction with the appellate court, and what was the results of that?
I brought up all these issues after you recuse the judge. You have 10 days to file a writ of mandate, which is a writ that you command the appellate court to fix the lower court's errors. So I did that for every judge that I recused except for Judge Talamantes, and they denied the writs. So I objected to them denying them, and they sent the paperwork back in the mail. So that let me know that they don't want to do what they're supposed to do. A lot of these people are involved in fraternal groups and all kind of things that people wouldn't know about, and they allow that to, alter the decision. It's really about money and who you know and who you pay. And my experience has been is that they have resurrected the Jim Crow laws. It's Judge Adams, and it is what it is, to where you have laws for black people and you have laws for whites. They're not going to tell you this, but that has just been my experience, that they have treated me less than an animal, and they're doing all kind of legal things. For example, the child support is really peonage or in-debt servitude, and that was abolished a long time ago. It's bill of pains and penalties where they target black people or males or men that want to be fathers. You're not supposed to do a bill of attainder. So a bill of attainder is when you go after a group and you target them based on a group, like the child support goes after non-custodial parents or fathers, which is illegal. But since this is a billion-dollar industry, they get away with that. And this is what they do in the court.
So would you consider them as feeling as if they're above the law instead of judging or being fair to the law? They're above the law.
Yes, they're above the law. You bring up a good point. As stated, and I don't want to be redundant, but I'll be redundant for the people that need to know. They're abusing their duty. The judges go by the canon law, and they're supposed to be impartial without bias. But their courts are corporations, so they use the moniker in the best interest of the child, and they suspend the Constitution, the trial by jury. So this breeds the corruption that they collect the child support money, and that pays the state treasury, and they get incentive bonuses for that. So this is how they're above the law. They get the money, and they don't uphold the Constitution. These are the government individuals, but the government is really the people, but not in a way that the people working for the government are oppressing people under color of law. So they are above the law in the sense that they are not doing people justice. They're breaching their contract of duty and their fiduciary duty to what they signed up for. And that's not what they're supposed to do. But as stated, a lot of people know this in the arenas, like the courts and just the whole thing, but they're not going to say anything because they're working and they don't speak out against it.
So it seemed to me like this is designed to set up like a mafia crime family, to where the judge is the godfather, the lawyers are the ones who make up the people they're going to rob, and the bailiffs are the muscle. Because it seemed like the sheriff, like you mentioned once before, when you went to ask a question, they asked the sheriffs to remove you from the court, as if they just got intimidation factors from all areas in the courtroom.
Yes, and as stated, my good brother Reggie has stated that this is designed to separate the family and target men and also black men. They want all the men and black men on this child support stuff, and they want you to go into debt. They make money by separating the family unit, and that's what they do. Is while they separate the family unit, they're able to get the money, and none of these people are in the best interest of the child. Here I am trying to be a father to our child, and I've been to like 3 or 4 courts. The child support say I owe money, but they can't prove that I owe the money. They can't validate the debt. They bring me to the probate court, and they're trying to steal our child with void and false orders. So this is the example, is that when you want to be involved in your child's life, that you face this kind of resistance, because these courts are for profit. You know, it's deeper than what people think. They're registered with the Washington, D.C., and these are for-profit businesses. There haven't been any real judges since 1789, and they more act on behalf as being an executive administrator. So what I mean by that is that when Judge Adams tried to sign a court order, a child support court order, that's not what a judge is supposed to do, because it violates the separation of powers doctrine, meaning that the branches of government are separate but equal. So meaning that you have the executive, judicial, and legislative branches, but the judge is acting as an executive administrator or a clerk behalf of those agencies, trying to sign people up for child support, putting individuals on restraining orders on them, putting individuals to pay third parties for supervised visits. These are all commercial transactions, and these are what the judges are doing, that they have turned their court to a store or something as a corporation, and they don't follow